Good morning. Are you Anthony Mendoza?
Yes, ma'am.
And Mr. Mendoza was previously in court and entered pleas of true to counts 1 through 13 in a motion to revoke probation. Currently on probation for driving while intoxicated, third or more. That was a 6-year sentence that was probated for 6 years. I've received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir. Yes, sir, we have.
Are there any additions or corrections to that report?
Oh, yeah. Yes, they do.
All right, Mr. Parker, you may proceed.
Well, just a couple things I want to address. It's a situation I see quite a bit where he's ordered to have the scram and interlock. It's costing him $600 a month, and he's having to go to work, but yet he's not supposed to drive, and so he's driving with an invalid license, and he's not able to work, and he can't afford to pay for the things he needs to do, such as the 12-step program, the GD program. All those things require money, and that's one of the big issues. But more the things I'm concerned about is that it says that he went to the safety relapse program. I'm not sure exactly what happened, but he says he never went to the safety relapse program. I don't know if he was ordered to go and he didn't go, but I think he was in custody at the time, and I'm not sure how that happened. But he also says he's never tested positive for cocaine, which is alleged in here. It addresses an issue that he apparently had with one of the directors of the facility where he became combative. And this also, in turn, is tied to a scram device. He ended up developing a big sore on his ankle, so he would put his sock behind the scram device. And in this incident, he was frustrated and he wanted to take this boot off to show the director the problem that he had. That's when they were saying that he was being disruptive. He has no other felonies, Judge, and he wants opportunity to go back to. He wants to complete his probation. He wants to do the safety relapse. I'd like to hear what they say of what happened with that, but I'm sure there's an explanation, and I think you'd also like to address the court.
Well, let me first make sure I've got the timeline because it appears that I see that safety he completed and then was placed on zero tolerance in the high medium caseload. And after that, there was an issue where he was testing positive again for alcohol and cocaine, which I understand he denies the cocaine, but that's what this alleges. And in October of 2022, I'm assuming through an administrative hearing, was granted relapse safety.
Yes, ma'am. There was a motion to revoke that was filed and came before the court, and he was ordered to go to relapse safety, and he absconded. And
So he wasn't in custody. Okay. And then so we didn't see him again until August 11th of 2023 when he was arrested in Houston. So here's the thing. Whether you probably didn't get any paperwork. Come up here to the front in the middle here. From at least October of 2022 until August 11th of 2023, you wouldn't have known about anything because you quit going to probation. You were an absconder. And the only reason we found you is because you were arrested in Houston for aggravated assault with a deadly weapon. And then in May, we get you back here and you were sanctioned to 180 days in jail. So this is the third time, it looks like to me, that you would have been given an opportunity to remain on probation. I gave you upfront time, continue you on probation. Courtesy supervision was sent to Harris County. And then we have the scram device issues still, alcohol violations, interlock violations, aggressive behavior, ongoing alcohol use. So if you didn't do the relapse safety, it's not anyone's fault other than your own, because if you didn't know about it, it's because you weren't going to probation. Mr. Nichols?
Judge, I think it's pretty clear. He was put on zero tolerance a couple of years ago, and here we are on the second time.
Third.
Multiple times.
Yeah.
And I don't know what else we could do. So obviously, I agree with the probation department's recommendation for revocation. I think he's had more than enough chances to. In fact, there was one thing I don't make the court aware of. I've called this
Martinez, real quick.
Yeah, sure. Ms. Martinez, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead.
Ms. Martinez, you were the supervisor. Well, Mr. Mendoza was on Harris County Supervisor, correct?
Yes.
And you were back in October when he started having his violations. And his warrant was issued. Did you advise him to turn something?
Yes.
And what was his response to it?
He had responded with an email that said, "Ha."
That was his only reply to you. Did I ask you to print me out a copy of that?
Yes.
Show me what Martin states it. One, purposes of hearing, is this a copy of the email with his reply to you? I took her to the defense attorney. I've turned it for purposes of this hearing offer states that one.
It's admitted.
And is that pretty consistent with this level of cooperation that's in probation?
Yes.
No question, Your Honor.
Any questions?
Just a couple. I want to clarify on the relapse program. You said he was in, y'all came to court on motion to revoke. Is that my understanding?
Yes.
And so the safety relapse was ordered by Judge Wicks,
Yes.
and he was here. Bennett was here. Mr. Mendoza was here that night.
Yes, sir.
Well, wouldn't he have been taken into custody?
Because I wasn't awesome.
Okay.
It looks like the hearing was completed over the phone. Okay, he was not here. It was over the phone with the supervisor at that time. Due to him residing in Houston, he reported he had a lack of transportation to report back to the hearing at that time because he had tested positive for alcohol and cocaine. The supervisor had recommended complete relapse safety and issue a warrant for his arrest. So he was made aware at that time that he was going to have a warrant and we were requesting relapse.
I have no further questions for Judge.
Right.
I have no questions.
Your Honor,
Thank you, Ms. Martinez.
I think he wanted to address the court, but we never did.
Sure.
With our
Go ahead.
inspector tell the court. Anyone tell the court?
You're saying I went to safety.
Nobody's saying you went to safety twice. We're saying you went to safety. Hold on. Don't listen. I'm going to let you talk. Don't talk over me. We're saying that you went to safety and then that you were ordered to go to the safety relapse, but you never came and turned yourself in after that phone call where you were told that there was to be a warrant for your arrest. So no, you never went to safety relapse. Go ahead.
She said I was supposed to turn myself in. That was after I did the 9 months where at 30 years old got dropped to a misdemeanor terrorist threat.
Mm-hmm.
So when I was here, y'all let me out. And then was trying to work, and they kept saying that I was messing with the scam device.
Okay.
So I was actually at work and she sent a message to my phone. And I was trying to work and trying to pay, for the devices and stuff, since they were violating me for the operating my truck without court permission.
Mm-hmm.
So that's when I just didn't turn myself.
Right. So did you respond? Is that email? That was
Yes,
that's what you thought about all that?
Yes, ma'am. I did actually say.
You thought that was funny?
It's because I was agitated and I was taking lunch at work, and I was trying to do things, trying to make money to take the classes, but with being on the scam device.
Well, you had money to buy alcohol. You hadn't, because you kept drinking, because you kept messing. I mean, Mr. Mendoza, you have been given so many opportunities on this probation, and I understand that those things are expensive. However, if you had at any time stopped testing positive and having blood alcohol readings that were positive on those things, then you could have eventually gotten off of those. I don't keep people on those for very long. But the reason we had to keep doing it for you is because you kept drinking. You kept messing up. And so you don't get to say, I kept messing up. I mean, seriously, you got the initial probation in 2021. You got relapse. I mean, you got safe P. You got some upfront time because of the Harris County issue. Didn't revoke you. Haven't revoked you 3 times. Haven't revoked you. And here we are with all of these violations.
The TDCJ program I was doing, the only time I had issues when I had the foot problem that I got from the halfway house. That's the only reason they said I absconded from the TDCJ program.
Okay.
I've actually done well through the program, through with the supervised division. The only time I messed up is when they stopped supervising me and made me go do these things by myself.
Well, I mean, how old are you? How old are you?
I'm 43.
43 years old.
And I have no felonies on my record except for this.
That doesn't mean anything. You have this felony and you have 6 years hanging over your head. And you've been given all the tools. You went to SafeP. You got to aftercare. At some point, you have to take those tools and do for yourself and not come in and say, well, they made me do it for myself, so it's somebody else's fault that I kept drinking. We gave you the tools.
If I can
We're done. At this, we're done. No, we're done. At Mr. Mendoza, turn around. You can say whatever you want, but you're going to face me and you're going to get your sentence. And if at this time I could give you more, I would, I promise you, but I can't. So I'm going to find that you entered your pleas of true to counts 1 through 13 freely and voluntarily. Find those counts true. Find sufficient evidence to revoke your probation, and at this time revoke your probation. Sentence you to 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you a certification of your right to appeal. This was not an agreement, so you do have some rights to appeal. Y'all need to sign that before you leave right now. You need to sign that you're getting a copy of it, and then we'll give you your copy. And then when you're done with that, you can go back with the bailiff.
Here's a classic legal catch. 22. Court order conditions that cost money, but the defendant can't legally drive to work to earn that money. It's a vicious cycle a lot of defendants face. But remember, financial strain isn't a legal excuse for violating probation. Judges see this as personal accountability territory. And there it is, the bombshell. While he's already on probation for DWI, Mendoza gets arrested again, this time for aggravated assault. That's like showing up to traffic court with a new speeding ticket in your hand. From this moment on, the judge's patience is hanging by a thread. All right, so at this point, the probation officer just confirmed that Mendoza knew there was a warrant and joked about it. Literally replied to an official email with, "Ha." What do you think that says to a judge? Drop your guess in the comments. Leniency or revocation incoming. This is where years of second chances run out. The judge has given Mendoza multiple opportunities, counseling, programs, all tools to rebuild his life. But when accountability doesn't stick, compassion runs out. You can feel the shift here, that moment when the system stops negotiating. 6 years in prison, the maximum she could impose. It's not just a sentence. It's the full consequence of ignored warnings, missed opportunities, and that one dismissive email that probably sealed his fate. Moral of the story? Probation is mercy with conditions, and every violation chips away at it.